This is indeed, Millers, according to me, a historic moment in many ways. First, Millers, that your Lordships will be analyzing why history was tossed out on the 6th of August 2019. Whether the procedure adopted by Parliament was consistent with what democracy stands for, whether the will of the people of Jammu and Kashmir could be silenced in this fashion, whether they will be denied a representative form of government through a diktat of the Union inconsistent with our Constitution. It is also historic because it has taken 5 years for your Lordships, Millers, to start hearing this case. And for 5 years, Millers, there has been no representative government in the state of Jammu and Kashmir. It is also historic because you will have to interpret Article 356 of the Constitution of India, an article which seeks to restore democracy. And how do that process? Through an article which sought to restore democracy, you have decimated democracy. Can that be done under Article 356? That the state of Jammu and Kashmir historically represented a very unique relationship, unlike princely states and the states of India which were integrated into the Union. Whether that historic relationship between sovereign authorities could have been jettisoned in this fashion by seeking to amend the Constitution and seeking to efface Article 370. Whether, Millers, a governor of a state could have, on the 20th of June 2018, decided that I will keep the assembly under suspended animation, which is the power of the governor alone under the J&K Constitution, without even trying to find out whether they can form a government or not. Because on the 19th of June, a particular party withdrew support, and on the 20th of June, the governor passed this order. Whether on the 21st of November 2018, Millers, a dissolution of the assembly could have taken place before the imposition of Article 356. The governor on the 21st of June dissolved the assembly without reference to 356. And thereafter, Article 356 was used. And the manner that it was used will be, Millers, I will address your Lordships on those issues. These are issues that will arise for your Lordship's consideration, never raised, never decided by this court. So in that sense, too, it is historic. So, Millers, I will proceed because there is a historical context to the state of Jammu and Kashmir, Millers. So I will have to take your Lordships through that history. And if your Lordships will permit me, Millers, I'll start with a list of dates.
Mr. Sibal, as all counsel know that all the arguments, we have the benefit now of live transcription. So the arguments are being simultaneously, we have transcripts in the court on the basis of, speech to text software. Like in the Maharashtra case, by the end of the day, the transcripts will be given to the arguing counsel. Your juniors can just verify that there are no mistakes. If there are any corrections, they can be given to the registry so that we will upload them immediately on our website. So they are available for everybody then to, that will also help counsel who are following. Of course, it helps us as well as everybody else.
So, Millers, I'll start off with the list of dates, which is, Millers, Volume 2, Written Submissions, Volume 2, PDF, page 33. We were reluctant students, Millers, but your Lordships ensured that we become disciplined students. It's because it's somewhat elaborated because it will give you a flavor what the issues are, Millers. Millers, before this, may I, Millers, want to make one statement clear, Millers, that we stand here on the premise that the integration of Jammu and Kashmir into India is unquestionable, was unquestionable, and always remain unquestionable. That was a given. And despite that, Mullahs, the whole structure was overnight, Mullahs, changed through a process which I will demonstrate was unconstitutional. When your lordships will be dealing with this matter, there will be four legislations in a sense that you'll be dealing with. One is the Constitution of India. The second is the Constitution of India as applicable in the state of Jammu and Kashmir. Third is the Constitution of Jammu and Kashmir. And fourth is Article 370. And the interaction between these three constitutions in the context of Article 370 is something that your lordships will have to look at as we move forward. But please keep that in mind. The reason why I say Constitution of India is applicable to the state of Jammu and Kashmir, that over time, there were several orders issued, constitutional orders from time to time, which were incorporated in the Constitution of India as applicable to Jammu and Kashmir. The result was that most of the powers most of the responsibilities and powers were actually in tandem with the Constitution of India. There was, in fact, really no difference other than Article 370 itself. All the laws were applicable, except that those laws were replicated in the constitutional orders of the government of India. So therefore, there was no reason to take away this right. It's in that context, Mullah, that I'm mentioning this. Now, Mullah, I'll go to the list of dates. On the 9th of March, 1846, the Treaty of Lahore was executed between Maharaja of Lahore and the British government, resulting in the transfer of certain territories to the East India Company, in particular under Article 4 of the treaty. The Maharaja cedes to the Honourable Company all its forts, territories, rights and interests in the hill countries which are situated between the river Beas and Indus, including provinces of Kashmir and Hazara. Earlier, Jammu's Maharaja Gulab Singh's General Zorawar Singh had invaded Ladakh in 1834. Ladakh came under Dogra rule and was incorporated into the state of Jammu and Kashmir in 1846. During the Sino-Sikh War, the Qing Empire invaded Ladakh, but the Sino-Tibetan army was defeated. Ladakh was claimed as a part of Tibet by Phuntstok Wangyal, a Tibetan communist leader. In 1947, partition left Ladakh a part of the Indian state of Jammu and Kashmir to be administered from Srinagar. On the 16th of March, 1846, following the Treaty of Lahore, the British government executed the Treaty of Amritsar on March 16, 1846. Under the treaty, the hilly mountainous country with its dependencies situated in the east of River Indus and west of River Ravi, including Chamba and excluding Lahore was transferred by the British government to Maharaja Gulab Singh of Jammu. The reason was simple, Maharaj. There was a violation of the Treaty of Lahore, and therefore compensation had to be paid, Maharaj, to the British government. He was not able to pay that compensation. In lieu of that compensation, these territories were ceded. That's what happened. On the 30th of June, 1857, Gulab Singh died and was succeeded by his son, Ranbir Singh. Following the passage of the Government of India Act 1858, territories formerly in possession under control of the East India Company were vested in the British monarch, in whose 1885 Maharaja Ranbir Singh died and was succeeded by Maharaja Pratap Singh. In 1889, 30th of August, the Interpretation Act of 1889 was passed by the UK Parliament. Section 18.4 of the Act defined the expression British India. All territories and places within Her Majesty's dominion, which are for the time being governed by Her Majesty through the Governor-General of India. In addition, the term India was defined under Section 18.5 as British India, together with any territories of any native prince or chief under the suzerainty of Her Majesty exercised to the Governor-General of India. You will note here, Mother, Jammu and Kashmir is not part of this. In 1925, Maharaja Pratap Singh was succeeded by Maharaja Hari Singh, the last ruler of the princely state of Jammu and Kashmir. And on the 20th of April 1927, The expression state subject was defined in the state subject definition notification dated April 27, which was issued by Maharaja Hari Singh. This notification classified state subjects into 4 classes and subsequently became the basis for the definition of permanent residents of Jammu and Kashmir under the Constitution of Jammu and Kashmir and Article 35A of the Constitution of India. Your Lordships need not go into it because we are not really dealing with that issue, but I'm just mentioning it. On the 22nd of April 1934, Maharaja Hari Singh enacted Regulation 1 of Samvat 1991 on April 22, 1934. Wherever there is Samvat, Malad, if you take away 57 years, that gives you the year. The regulation established a legislative assembly for the state of Jammu and Kashmir called the Praja Sabha. While certain legislative functions were delegated to the Praja Sabha, the ruler, Maharaja Hari Singh, retained supremacy over all legislative, executive and judicial matters. On the 2nd of August 1935, the Government of India Act 1935 was passed by the UK Parliament. The Act established India as a federation comprising governors' provinces, chief commissioners' provinces, the Indian states which had or would accede to the Federation of India. Under Section 6 of the said Act, the ruler of Indian princely states was empowered to execute an instrument of accession, declaring that he accedes to the Federation of India, subject to the terms of such instrument. Under Section 2, an instrument of accession was to specify matters with respect to which the federal legislature would have competence to legislate for a particular state and the limitations, if any, on the legislature's powers to make laws or exercise executive authority over such state. Notably, as the state of Jammu and Kashmir was not a part of British India, provisions of the Government of India Act 1935 did not apply to it unless an instrument of accession was executed by its ruler in accordance with Section 6. On the 7th of September 1939, the Jammu and Kashmir Constitution Act 1939 was promulgated. While Maharaja Hari Singh retained sovereignty and supremacy over all legislative, executive and judicial functions, the Act provided the Praja Sabha to make laws for the entire state of Jammu and Kashmir or any part thereof, subject to certain conditions. Further, the said Act vested executive functions with council consisting of a Prime Minister and other ministers appointed by the ruler. The Act also provided for the High Court, which had been established by the ruler in 1928, to be a court of record with jurisdiction to adjudicate upon inter alia civil suits, civil, criminal and revenue appeals. On the 16th of May 1946, the Cabinet Mission issued a statement regarding its report. Under paragraph 15(1) and 4 of that statement, the Cabinet Mission plan envisaged a Union of India where the Union would have responsibility over defense, foreign affairs and communications, and the states would retain jurisdiction over all other subjects not ceded to the Union. On the 12th, 22nd of May 1946, the Cabinet Mission issued a memorandum titled States, Treaties and Paramountcy, which affirmed that following the establishment of an independent government in India, the paramountcy of the British monarch over Indian states would lapse and paramountcy power over their respective territories would return to the states. On the 19th of December 1946, the Constituent Assembly of India, in terms of the Cabinet Mission Plan, met for the first session. On the 22nd of January 1947, the Constituent Assembly of India unanimously adopted the Objectives Resolution, which declared the Assembly's firm and solemn resolve to proclaim India as an independent sovereign republic. Importantly, paragraph 3 of the Objectives Resolution declared that princely states that had joined the Union of India, and I quote, whether with their present boundaries or with such others as may be determined by the Constituent Assembly, and thereafter according to the law of the Constitution, shall possess and retain the status of autonomous units, together with residuary powers and exercise all powers and functions of government and administration, save and except such powers and functions as are vested in or assigned in the Union. On the 25th of January, 1947, the Constituent Assembly adopted a resolution for the establishment of the Union Powers Committee to inter alia draw up lists of matters included in the and interconnected with the subjects assigned to the Union before the framing of the Constitution. On the 5th of July 1947, the Union Powers Committee submitted its second report to the Constituent Assembly. Significantly, the report noted in paragraph 3, and I quote, "It is necessary to indicate the position of Indian states in the scheme proposed by us. The states which have joined the Constituent Assembly have done so on the basis of the 16th May statement. Some of them have expressed themselves as willing to cede wider powers to the center than contemplated in that statement. But we consider it necessary to point out that the application to states in general of the federal list of subjects, insofar as it goes beyond the 16th May statement, should be with their consent. It follows from this that in their case, residuary powers would vest with them unless they consent to their vesting in the center." And your Lordship knows whether that consent was given. The UK Parliament on 18th of July 1947 passed the Indian Independence Act of 1947. Under 1.1 Section 1.1 of the Act, from August 15, 1947, two independent dominions, India and Pakistan, were to be established. Significantly, Section 7.1b of the Act stated that following independence, the suzerainty of the British monarch over Indian states would lapse and return to the rulers of such states. Resultantly, as sovereign states, as many as 562 princely states had the choice to remain independent or accede to either of the two dominions established by the Act. Lastly, as a transitional measure, Section 8 prescribed that provisions of the Government of India Act 1935 would continue to apply to the Dominion of India and Pakistan subject to certain conditions. Under Section 9 of the Indian Independence Act, the Governor General issued the India Provisional Constitutional Order 1947, which made certain sections of the Government of India Act 1935 applicable to India, until other provisions were made by the Constituent Assembly. Among the applicable provisions was Section 6, which dealt with accession of princely states to India through the execution of the instrument of accession. On the 15th of August, India attained independence and was partitioned into the dominions of India and Pakistan. Further, as British paramountcy had lapsed, princely states that had not executed instruments of accession with either dominion became independent states. These included the states of Junagadh, Hyderabad, and Jammu and Kashmir. On 26th of October 1947, the ruler of Jammu and Kashmir made an offer of accession to India, asking for help from the Indian Dominion to meet a grave emergency caused by mass infiltration of tribesmen drawn from distant area of northwest frontier, coming regularly in motor trucks, Manshera-Muzaffarabad road, and fully armed with up-to-date weapons, which cannot possibly be done without the knowing of the provincial government of the Northwest Frontier Province and the government of Pakistan. In the instrument of accession signed by him on the same date, he declared his accession to India subject to the terms of such instrument. Under Section 3 of the instrument, the Dominion Legislature had authority to make laws for the state of Jammu and Kashmir on the subjects of defense, external affairs, and communication. Article 7 provided that the instrument of accession did not commit the ruler to the acceptance of any future constitution of India, while Section 8 vested sovereignty over subjects not acceded to India in the ruler. But there's just two issues I want to flag here. Your Lordships, in the course of this hearing, will have to determine what does a Constituent Assembly stand for. A Constituent Assembly stands for enacting a constitution for the future of the territories with respect to which the constitution is to apply. It's essentially a political exercise. It's not a legal exercise. It's a political exercise to take into account the aspirations of people, what kind of state the people want, and in the context of that, draft a constitution. Right? The constitution itself is a political document, but it takes into account the aspirations of several segments of society living within a united territory, takes into account their separate aspirations, and in the context of that, drafts a constitution to meet the aspirations in future years for decades to come. So the exercise of a constituent assembly is a political exercise. The drafting of the constitution, which is a political document, is a political exercise. But once the constitution is drafted, once it is come into place, then all institutions under the constitution are governed by the constitution. And those institutions are limited in the exercise of their powers because they have to exercise their powers consistent with the provisions of the Constitution. Parliament cannot convert itself into a constituent assembly. That's done. Today, the Indian Parliament can't say by a resolution that we are the Constituent Assembly. As a matter of law, they can't say it. Because they are now cabined, cribbed, and confined by the provisions of the Constitution. They can't pass a law which is outside the list. They can pass a law under 254. If the state passes a law, it's repugnant. They must adhere to the basic features of the Constitution. They can't suspend, except in emergencies with external aggression, the fundamental rights of people. That also is limited under provisions of the Constitution. The executive can't mothers do things which are contrary to the law, and the judiciary then declares the law. But no parliament can convert itself into a constituent assembly. And if you accept that proposition of law, it has enormous consequences for the future of my country. And that is one of the most salient and, according to me, the core issues to be decided in this case. Because Parliament said that we declare the legislature of the state of Jammu and Kashmir as the Constituent Assembly. Where does Parliament get that power? How does Parliament get that power? Under which provision of law? Not under 356.